Howdy. I almost left this chapter out. So this is going to be a quick overview of computer forensics, and I'm going to tell you why. First of all, as you can see, I'm a lawyer, and I'm also a PhD in computer science. But the fact of the matter is, I went to law school about 10 years ago. I passed the February 2009 bar exam. I did that after 9 years of working in high tech in Austin, which I did after I started my own company here while I was getting my PhD. So I've been around a lot of lawyers, and I've been around a lot of legal situations. If and when you ever find yourself in a situation like this, you must seek competent legal guidance. Now, let me tell you, as a software engineer, entrepreneur first, and a lawyer second, I do everything I can when I work with people to empower them that they don't need a lawyer. There's 2 books, if you're an entrepreneur, everybody should have on their shelf. However, there are times when you need to get legal advice. And anytime you begin to talk about forensics or bad things happening, that's it. So I'm going to give you a brief overview of this, but by no means do I want you to put this in your back pocket and say, okay, I know how to handle it. When there is an incident, if you are working for the government or you're working on industry or you're working for yourself, you need to find competent legal guidance. And competent legal is in some ways an oxymoron. Too many lawyers do not understand the technology. So they're going to have you do things that may or may not make sense and may or may not cover the totality of the problem. Okay? My attribution slide, like I said, this is going to be quick and dirty. I'm going to talk about it. I'm going to talk about collecting and preserving evidence. The other aspect of this that I want you to be aware of is the problem if you don't collect and preserve evidence. Even if you're down, you're a computer person, you're working an incident, you're working 20 hours a day, you're trying to bring the power grid back up, or you're trying to figure out what happened to, the customer accounts or something. The one thing you can get in trouble with is if you improperly manage evidence. I've mentioned it before, the engineer in BP who was charged under criminal counts, went to trial twice, finally pled out to misdemeanor, probably $400,000 or $500,000 in legal fees, which came out of his pocket. Bad press, everybody knew his name. And he wasn't even involved in the catastrophe that was Deepwater Horizon in April 2010. But according to the feds, he had deleted text that were necessary to collect and preserve evidence. So again, this is a serious topic and not one that you can take lightly. A lot of times you'll see forensics classes offered here. If you're interested in that, great. But always remember, there's the technical and there's the legal. And the technical is get the job done, bring us back. Legal is the aftermath, right? If there's an incident, it may be 5 and 10, 15 years in courts. Okay, so we're going to talk about some quick definitions. The best evidence rule is what it says. It's a legal principle that supports, give me the best you have. Give me the true copy. Don't give me a copy if you can give me the true copy. Don't give me a derivative if you can give me the source, okay? And competent evidence is just that. It's evidence that's legally qualified and reliable. Demonstrative evidence is evidence that can be used to aid the jury and can be formed in a model, experiment, chart, and so on. People don't realize it, but judges will bring in whiteboards or they'll do this or that and to convey to the jury, how can we demonstrate this happened? Put it in simple terms. For instance, if I were going to try to explain encryption to a jury and it was very necessary for them to understand, I might actually bring in some physical locks and use an analogy of keys and locks to explain encryption. You want to demonstrate. You want to get your evidence down to where people can understand what happened and make sound judgments. Direct evidence, it's oral testimony, eyewitness account, something that I can point to and say I was there. And then I always love this, the hearsay. You always hear, oh, that's hearsay, and it's not direct. And you can teach a whole class on the exceptions to hearsay. Documentary evidence, it's business records, printouts, manuals, and other items. You're probably all too young to remember when Microsoft got caught up in the antitrust suits. When was that? 80s and 90s. And they went back and got all the emails and, things that were said. And people put things in emails and don't realize that is, in fact, a business record. And it can be used in evidence. I caution people, caution people. Separate your business and personal email. Never put anything in a business email that you consider personal. Let me tell you one story is when, after again, Deepwater Horizon, there were members of the Coast Guard whose girlfriends were sending them pictures and stuff, and you can imagine they were using their government accounts. That all got swept up in discovery. It belongs to the entity that controls the email. So again, just use common sense. If you've got personal communication, even if you don't think it's embarrassing or you make comments, keep it personal, keep it out of discovery. If I'm an attorney and I'm going after your company, my big net that I can sweep up evidence is only pertaining to business assets. But too many times we forget what constitutes business records, printouts, manuals, other items. The exclusionary rule. I don't like this definition because it's basically the Fourth Amendment. It precludes illegal search and seizure. If you were in my law and policy class this summer, 2, 3, maybe 4 weeks ago now, the Supreme Court ruled on Carpenter, changed the Fourth Amendment. I immediately updated my lecture. I was anticipating the court's decision. I just didn't know how narrow it would be, but it basically affects Fourth Amendment rights on your cell phone. And it's just a little crack in the door on privacy, but all those little cracks in the door are important. So instead of the exclusionary rule, I like to say, the Fourth Amendment of the United States Constitution precludes illegal search and seizure. That is a protection everyone has if they are within the boundaries of the United States, with some exceptions at the border. Okay, the border, you basically have waived your Fourth Amendment rights coming back into the country. So any evidence collected in violation of that Fourth Amendment is not admissible. And there's also evidence collected in violation of certain laws, like electronic communications privacy law or other U.S. code. So it's exclusionary. But what I like to say is, I like to keep it to the source. Is it violate the Fourth Amendment? What does it violate? Forensics, preservation, identification, documentation, interpretation of any kind of computer data for use in legal proceedings. Free space, I don't even know why that one's on here, but it's basically a storage medium that's available for the operating system to use. Now, hearsay. Oh my gosh, I love hearsay. It's a secondhand evidence rule offered by a witness that's not based on personal knowledge. So typically, hearsay is not allowed, but there's like myriad exceptions to the hearsay rule. Statement against interest is an exception. Excited utterance is an exception. Okay, so sometimes computer-generated evidence can be considered hearsay. As a maker of the evidence, the computer itself can't be interrogated. Well, that's kind of stretching it. Everything comes from something. But there are exceptions being made when items such as logs and headers are being accepted. Now, so the hearsay rule, through Dr. Conklin's perspective, is looking at best evidence. All I want you to know as hearsay is evidence should be direct evidence. However, there are many exceptions. If you watch Law and Order and a good court shows that actually get it right, objection, Your Honor, hearsay, and immediately excited utterance or statement against interest or something like that. And then that's a known exception where you can allow hearsay in. I'm going to skip some of these. Magic number, if you're interested, partition, because I don't want to get too much caught up in this. They're all in your book. And I want to keep this video shorter than the videos I've been trying to do. I tend to talk on, because obviously you can tell I love this topic. So we do computer forensics basically to investigate and analyze computer systems as related to violation of law, investigate and analyze computer systems for compliance, respond to requests for digital discovery, which is e-discovery. E-discovery now, quite a bit of it's done automated, which means it casts a wide net. And the conflict you get into is your discovery has a very limited time frame. I must produce documents, both physical and electronic, within, let's say, a 3-week period. And I go to put my parameters in my e-discovery software tool, and, 500,000 corporate emails come up, right? So I just want you to kind of get an overview of this. So like I said, I'm going to try to walk through this quickly, talking about what evidence is. People sometimes don't know because they're, he says technically educated. Well, our whole notion of evidence again has changed as the internet and digital came up. An interesting side note is many years ago, and someday I got to find the source, the first time ever in the United States, DNA was introduced in a crime trial. The jury found the defendant not guilty, and the holdout was an engineer who did not believe in DNA. You have to find that one sometime. And it's like now everybody accepts DNA, right? But at that time, it's like, no, I'm an engineer. Those little chromosomes, that can't be true. So we talked about direct evidence, real evidence. I'm going to lead the definitions to you. Like I said, this is going to be a quick and dirty overview. We've talked about standards of evidence. The Dahlberg standard, again, you don't need to know this. This is on the standard of who the expert is that deems this evidence as being acceptable as evidence. And then the Dahlberg standards, it's their skills, knowledge, experience, training, da-da-da-da-da-da. That's basically what you need to know. The standards of evidence is, and this is something a lot of people don't realize, the judge is a gatekeeper. The judge and or the jury are called the fact finders, right? If you have a constitutional right to a jury trial, in most situations, you can waive that right and ask for a trial with just a judge. But when you come to evidence, they don't look at the jury and say, hey, should we accept this? The judge says yes or no. And if the judge makes an error, that's a point of appeal. Something that is also lost is your fact finder is your district court, your first level. Your appellate courts, your review courts, be they state or federal, only look at the written record, and they are limited to looking for mistakes in law. So if my client loses at the district level and I can write an appellate brief and say the judge did not allow this information in and he should have, that's a mistake in law. If I say the jury made a mistake and in this evidence, no, the jury was the fact finder. So you want to be at the appellate level, mistake in law. So the judge made a mistake. He either put evidence in he shouldn't have, or he didn't allow evidence in that he should have. You see this a lot now in criminal convictions that are being overturned when they say the prosecutor had exculpatory evidence that the defendant could have been found not guilty and didn't share it with the defense attorneys, right? Mistake in law, all right? So we've talked a little bit about standards. If you really want to get into this, please take my law and policy course. But this is why at certain points, in certain situations you find yourself in, you will want to come up and have legal representation, because a good lawyer is going to charge you a lot, but the first thing they're going to do is they're going to go look at case law, because your evidence standards are not statutory. They are case law, meaning judge-made law, meaning there can be a appellate decision that comes out in the Fifth Court, Federal Court, District Court, which governs Texas, or at the appellate court that covers Bryan College Station. I think that's the 10th Court out of Waco. I live in Houston. It's split between the 1st and 14th appellate courts. They're the ones making the rules regarding evidence. I can't go look at a law book. This is all common law. And that's why you need a lawyer who's going to, the first thing you always ask a lawyer is, what's the latest case law on that? So there's a process. We identify, we look at, we prepare, we approach, we preserve. The advice I want to give you all is to take this seriously. Don't be that BP engineer who had his life ruined for 2 or 3 years and now has to figure out how to pay off a $500,000 legal fee. Okay? Be careful what you put in personal email. When you are assigned something that is part of the forensic process, adhere to the rules. Document. You know, if you have a concern that something is not being done correctly, write it. Put it in an email and submit it. Put a memo to the file. Do something that you can go back. Because what we also think about in the forensic process, it's the aftermath. We are going to go back and look at, and yeah, we're going to interview people, but we're typically going to rely on what do we know that really happened at the time of the event, and we're going to look and give great credibility to the written record. So let's say something happens, and I'm your manager, and I tell you to do something, and you don't like it, and you come and tell me. And then later on, you were right, I was wrong, and there was a question of preservation of evidence. Well, I may have forgotten you told me that. I may have misunderstood you. I may be lying to protect myself. Whereas if you had a disagreement, you might send an email and say, hey, just make it friendly, make it light. Say, hey, just to be clear, we had this discussion and my analysis was this, and this is the interpretation you gave me, and we're going to go with that. You have now documented it for the record. Okay, so that's going to end our first video. I believe we have 3. Like I said, I'm doing in this class, it's been about a 10,000 mile flyover. I'm about at the 30,000 mile for this. Stay with me.